War has never been only about guns, tanks, or missiles. Throughout history, conflict has always had a second, quieter dimension, one that operates not on battlefields but in treaties, courts, maps, and definitions. In the 21st century, this silent dimension has evolved into something far more dangerous and far more effective.
Before we move forward, please like, share, and subscribe Strategic Vanguard and be up to date with the latest news and happenings from the world of defense, strategic, and international affairs. Tune into our video channels in YouTube and Rumble. And if you want to hear the audio version, tune into our Strategic Vanguard channels in Spotify and Amazon Music.
It is called lawfare. Lawfare is the use of law as a weapon of war. Not as a moral framework, not as a peacekeeping mechanism, but as a strategic instrument designed to weaken adversaries, paralyze decision-making, delegitimize power, and shape outcomes without triggering open conflict. In today's world, wars are increasingly won not by destroying armies, but by controlling narratives, rules, and legality. Traditional warfare seeks decisive victory through force. Lawfare seeks strategic victory through legitimacy. It does not aim to conquer territory overnight, but to slowly make resistance politically, legally, and diplomatically untenable. A nation facing lawfare may still possess strong armed forces, advanced weapons, and capable leadership, yet find itself constrained, accused, sanctioned, isolated, or hesitant to act. This is the paradox of modern power. Strength on paper does not always translate into freedom of action. Lawfare exploits exactly this gap. The roots of lawfare are not new. Even in ancient times, empires justified wars through religious or legal pretexts. Colonial powers perfected this by cloaking expansion under treaties, charters, and mandates. However, the modern form of lawfare truly emerged after the Second World War, when international institutions, conventions, and legal regimes expanded rapidly. The creation of global norms governing war, seas, airspace, trade, and human rights was meant to prevent conflict. Instead, it created an arena where conflict could continue under a different name. As military confrontation became riskier due to nuclear deterrence, legal and normative confrontation became safer, subtler, and more persistent. Lawfare thrives in gray zones. It operates below the threshold of armed conflict, but above normal diplomacy. It blurs the line between peace and war. A country using lawfare does not declare war. It files cases, interprets conventions creatively, passes domestic laws with extraterritorial implications, and selectively applies international rules. The objective is not to win a legal argument in good faith, but to impose strategic costs on the opponent. Delay becomes a weapon. Ambiguity becomes a shield. Legitimacy becomes the battlefield. One of the most striking features of lawfare is its asymmetry. Unlike conventional warfare, where strength often correlates with resources and technology, lawfare allows even relatively weaker actors to punch above their weight. A single legal challenge, international campaign, or narrative framing can force powerful militaries to pause, justify, or retreat. Democracies, in particular, are vulnerable. Their commitment to rule of law, transparency, and international legitimacy makes them cautious. Authoritarian systems, on the other hand, can afford selective compliance. They exploit legal systems without being fully bound by them. This brings us to the most sophisticated practitioner of lawfare in the modern era: China. China's rise is often analyzed through ship counts, missile ranges, and defense budgets. But one of its most effective tools has not been military hardware. It has been legal engineering. Nowhere is this more visible than in the maritime domain, particularly in the Indo-Pacific. China has demonstrated how lawfare can reshape strategic realities without triggering a shooting war. China's approach to international law is not one of outright rejection, nor of full compliance. It is selective, strategic, and calculated. Beijing embraces international law when it serves its interests and reinterprets or ignores it when it does not. This flexibility is not accidental, it is deliberate statecraft. In the South China Sea, China has used domestic legislation, administrative measures, maritime law enforcement, and historical narratives to advance claims that lack strong grounding in international law. Instead of resolving disputes through force, it has created facts on the water, and then wrapped them in legal and administrative frameworks. Artificial islands are a classic example. These are not merely military outposts, they are legal instruments. By transforming reefs into islands, China attempts to generate maritime zones, even when such claims are contested. Coast Guard laws allow Chinese vessels to enforce domestic regulations far from the mainland. Fishing regulations, environmental rules, and maritime safety norms are selectively applied to assert control. Each move is calibrated to stay below the threshold of war, while gradually shifting the status quo. Even when confronted with adverse legal outcomes, China demonstrates another dimension of lawfare, the ability to absorb reputational costs while retaining strategic gains. Arbitration rulings may be rejected, but the physical presence remains. Over time, the world adjusts to the new reality. This is lawfare's long game. It does not seek immediate validation. It seeks eventual acceptance. The United States, despite being a military superpower, has also engaged in lawfare, though in a different manner. Sanctions regimes, export controls, and legal instruments targeting finance, technology, and trade have become central tools of American power. These are not acts of war in the traditional sense, yet they can cripple economies, restrict strategic industries, and shape geopolitical behavior. Law, in this context, becomes an extension of national strategy. However, reliance on lawfare carries risks. Overuse can erode legitimacy. Selective enforcement undermines trust in institutions. When law becomes a tool of coercion rather than consensus, it loses moral authority. This creates a fragmented legal order, where rules apply differently to different actors. The result is not stability, but managed chaos. For India, the rise of lawfare presents both a challenge and an opportunity. India is fundamentally a rule-of-law civilization and a status quo power in the international system. Its credibility rests on adherence to international norms, peaceful dispute resolution, and legal consistency. This gives India moral strength, but it also creates strategic constraints. In an environment where others weaponize law, mere compliance is not enough. Strategic literacy in lawfare becomes essential. India's maritime posture illustrates this dilemma. As a nation with vast coastlines, critical sea lanes, and island territories, India has deep stakes in maritime law. It benefits from a stable legal order at sea. Yet, when confronted with aggressive legal maneuvers by others, India must respond not only diplomatically or militarily, but legally and strategically. Silence, delay, or purely reactive positions can be interpreted as acquiescence in the long run. The future battlefield is not just land, sea, air, space, or cyberspace. It is also the courtroom, the arbitration panel, the regulatory body, and the drafting committee. Strategic documents, domestic statutes, international submissions, and narrative framing will increasingly shape outcomes. Military planners must understand legal consequences. Legal experts must understand strategic intent. The separation between law and warfare is no longer sustainable. Lawfare also challenges traditional notions of victory and defeat. There are no surrender ceremonies in lawfare. There are no ceasefire lines. Instead, there are incremental shifts, delayed responses, frozen disputes, and normalized violations. A country may wake up one day to realize that while no war was fought, strategic space has been lost. This is the quiet danger of lawfare. The central question, therefore, is not whether lawfare exists, but whether states are prepared for it. Preparation does not mean abandoning international law. It means understanding its strategic dimensions, anticipating misuse, and responding with clarity and confidence. It means investing in legal capacity as seriously as military capacity. It means recognizing that legitimacy itself is a form of power. For India, the path forward lies in strategic engagement with law, not passive reliance on it. Law must be integrated into national security thinking. Legal narratives must be proactive, not defensive. International platforms must be used with purpose. Above all, India must recognize that restraint should be a choice, not a compulsion imposed by others' manipulation of rules. In the end, the most decisive wars of the future may not be remembered for their battles, but for their judgments, resolutions, and precedents. The weapons will be words, clauses, and interpretations. The damage will be strategic, not physical. And the winners will be those who understand that in the 21st century, the pen is no longer mightier than the sword. The pen is the sword.
Thank you for joining us on this Strategic Vanguard deep dive. If you found value in this analysis, don't forget to like, share, and subscribe to our channel. We bring you fresh deep dives every Wednesday and Saturday here on YouTube and Rumble, and you can also catch the audio versions on Spotify and Amazon Music. Just search for Strategic Vanguard Deep Dive. For more insights, articles, and discussions, subscribe to our blog at strategicvanguard.com. Your support helps us grow and bring you more in-depth analysis on defense, geopolitics, and strategy. Until next time, stay informed, stay strategic.